I'm here with my good friend and co-author Jorge Padilla to tell you about the third edition of our book, The Law and Economics of Article 102. And hot off the press, you will see this resplendent Spanish red, chosen personally by Jorge, in line with his cultural preferences and foibles. This edition of our book, I think, has been by far a more substantial effort in terms of workload than the second edition. In terms of the incremental effect that economists are interested in, there has been a net edition of 250 pages, and we have deleted dozens and dozens of pages. So it is a very, very substantial undertaking. We have, of course, discussed all of the marquee cases, which will be well known, the trilogy of Google cases, shopping, AdSense, and Android, the two Qualcomm cases, exclusivity and predation, and of course, leading court judgments such as Intel and the MEO discrimination case. In terms of the major changes, I wanted to highlight a handful of things. I think the chapter which really is the novel feature of the book is a brand new 61-page chapter on abuses in digital platforms. And I think Jorge and I have found this intellectually, legally, and economically probably the most difficult and interesting area in terms of updating, because it presents a number of conceptual conundrums and inconsistencies and challenges. These issues, of course, are not confined to the question of abuse. The market definition and dominance chapters also have new subsections on the impact of digital platform activity on market definition and dominance under Article 102. There is, of course, a significant discussion of the concept of abuse generally in the light of the Intel judgment, and of course, what is now effectively a global debate as to whether law monopolization should be recalibrated to deal with a number of perceived gaps. In terms of other chapters which have had significant open heart surgery, excessive pricing, in large part because of a series of national cases, has had very, very substantial additions. We're referring, of course, in particular to the Phenatone and Aspen cases. Discrimination has been substantially adapted in the light of the MEO judgment, which I think resets this area in a number of respects. The area of predatory pricing in the light of the Qualcomm decision has had substantial changes. And even in the context of remedies, we have for the first time since IMS Health in 20 years, an interim measures decision in Broadcom. And we have what is, in my view, a quasi-structural remedy in the form of Google Shopping, which we discussed in detail. And finally, in the context of patents, there has been a whole series of activity. I'm referring, of course, to standards, and that is a chapter which has effectively been rewritten, because at the time we did the second edition, all of the issues were essentially in an embryonic state. There has now been major litigation on a global scale to deal with a range of standards issues, which we discuss at considerable length. And finally, in the context of patents as well, there has, of course, been significant development in the context of pay for delay, paroxetine, and things such as product hopping. So this has been a very, very substantial update, probably the biggest piece of work we've done since the first edition. And therefore, we hope you enjoy it and we commend it to you. Jorge, can I hand over to you now to look more from the economics perspective as to how you see the last seven years and the evolution since the second edition?
Thank you very much, Robert. As you all know, the title of this book is The Law and Economics of Article 102. And one of its key characteristics is that we try to integrate the law with the economics. So the book and its evolution over time, from the first edition to this third edition, has been witness of a number of changes that have occurred in European competition law as to the impact and relevance of economic analysis in actual cases. And European competition law has indeed evolved considerably over the last few years. Now, while its objectives are many, and economic efficiency is just one of them, I think that what we have seen over the last few years in some of the cases is that the objective of the protection of consumer welfare has become much more important in Article 102. That the case law is, if anything, better grounded in economics today than it was 7 years ago. The role of economics in Article 102 cases has increased significantly, and this is something that you're going to be able to observe when you read the various different chapters. Price cost tests are systematically applied in excessive pricing, predation, rebates, and exclusivity cases, using cost measures such as avoidable cost and incremental, long-run incremental costs, which are economically rigorous. Competition agencies and courts are much more aware today of the need to formulate cogent theories of harm that are, indeed logical and well-grounded in economics. And they are much more careful in checking that the facts of the case fit with those theories of harm. Efficiencies, which so far had been largely ignored, are now much more relevant, and they have featured prominently in some recent cases. Now, not all decisions and rulings of the last few years reflect the increasing role of economics, but the trend is very clear. And to some extent, it is not surprising that you don't see a uniform adoption of rigorous economic analysis, because to some extent, economic analysis adds to complexity, and agencies and courts are reluctant to welcome changes that add complexity unless that is strictly necessary. But as I said, and you will find in the book, the trend is clear. Court rulings in cases such as Post-Denmark 1 and 2 and Intel have enshrined the importance of consumer welfare in Article 1 and 2, clarifying that the goal of competition law in the EU is not to protect inefficient competitors, but rather to protect the competitive process, allowing as efficient competitors to compete so that consumers benefit. Our personal experience is that both the European Commission as well as the national competition authorities of the member states scrutinize very carefully any allegation that is presented to them before opening formal proceedings, verifying not only that the facts are there, but that there is a cogent underlying theory of harm that makes economic sense, and then checking indeed that the factual evidence that is adduced fits with that theory. We are certain that that way of proceeding will be more and more reflected in future cases, and hope sincerely that the discussion of recent cases in our books, using an integrated law and economics approach, serves to shed light on the way that those cases should be handled in the immediate future. We are therefore not surprised to hear that judges at the General Court and the European Court of Justice are seriously considering how to ensure that their chambers obtain proper economic advice in order to assess, or when they are called to assess, competition matters. After all, the current trend towards a more economic approach has been largely driven by some of those judges, especially the author of the foreword of this third edition, Judge Niels Wahl. And that is one of the reasons why we call this edition the Wahl edition. We are, to some extent, reflecting on what judges have told us that the course of, or the trend is going, and we're trying to provide the readership help in assessing how those past cases and future cases will be, have been, and will be run using a proper, cogent, rigorous economic approach. Bob, back to you.
Okay, thank you, Jorge. Just to wrap up in terms of who the book is aimed at, I mean, the slightly glib answer is anybody who can afford it. The more serious answer, I mean, our primary role is as practitioners, and the insights in this book are really born from our practical experience working on cases in real time, sometimes bitter experience, I might add. So we hope in the first instance that what we bring to the table is a practitioner's approach to these issues. But at the same time, I mean, we both do substantial work in academic settings. And for me, the perfect combination really is a mixture of practice and academia. We think both approaches in isolation miss something. So there is an academic component, no doubt, in this book, which we have tried to reflect. Third, I think in large part because Article 102 has become a sort of an area of intellectual leadership for Europe on a global basis, with many jurisdictions wishing to adopt the approach taken in Europe. We hope that the book is also a guide to courts, regulators, and practitioners outside of Europe who are interested in thinking about these issues. And finally, what we have tried to do in particular, in relation to novel issues where the case law hasn't really addressed in detail, We have tried to set out the competing debates in a pretty neutral manner. On occasion, we have given tentative personal suggestions, but what we've tried to do, I think, is scope out the issues as completely as possible without being too didactic or expressing our views as conclusions. So we hope that this will meet a range of target audiences, but it is primarily a practitioner's textbook.